Hello everyone, I am Aleena Alex. The topic for today is maintenance under Muslim law, that is nafaka. Nafaka is an Arabic word which means what a person spends over his family. But in legal terms, it means food, clothing, and lodging. Under Muslim law, a man is bound to maintain his wife irrespective of his or her means and his minor children if he is not indigent. He is also obliged to maintain his other relatives from whom he can inherit if he has means to do so and they are indigent. Now we can go through certain definitions. According to Haidia, maintenance is all those things which are necessary to support of life, such as food, clothes and lodging. Many confine it solely to food. According to Dur ul Mukhtar, nafaka literally means that which a man spends over his children. In law, it means feeding, clothing and lodging. In common use, it signifies food. In the pre-Islamic era, there was no obligation as such for a person to maintain the other one. But when it's Islamic era, it's promulgated by Quran and it's an obligation. Now we can go through certain general rules regarding the maintenance. According to this rule, a person who doesn't have any property and related to the person by a prohibited degree can only claim for the maintenance. But when the claimant is a wife or a minor children or an unmarried daughter, it's an exception for the general rule. Now we can go through two principles regarding the maintenance, but they are contradicting to each other. The first one is helping others. It says that a person should help or maintain other in situations especially when they have no other means of surviving. But it also says that the person who is helping or maintaining the other shouldn't undergo any monetary loss while helping other. But we can also know that it's not possible to help or maintain other without any monetary loss. So both the points or the principles are contradicting to each other. Muslim law of maintenance is based on Islamic principles, Criminal Procedure Code, and Muslim Women Protection of Right on Divorce Act 1986. Now we can go through the maintenance of descendants. Father's liability to maintain their children is absolute. No way the father can run away from the liability, and it's only if the father is capable of earning. Maintenance is imperative even if the custody is with the mother. Mother can reimburse the money from the father. The father has to maintain a minor child who is unable to maintain himself, or the child is legitimate or illegitimate if the girl is married off but she is not able to take care of herself, and he also has to take care of the major son in conditions where he is physically or mentally ill and not able to take care of himself. The majority in these situations are considered according to Indian Majority Act 1875 Section 3. So the age of majority is 18 years. If the descendants are divorced and they made the child of the father has to take care of the child if she doesn't have any income. In the absence of capability of parents, the grandparents, that is maternal or paternal, can maintain the children, and it depends upon who comes forward or decided by the court. But the father-in-law doesn't have the duty to maintain the widowed daughter-in-law because she will get definitely the dower and it's meant for the maintenance of herself. It also says that in Hanafi law, if the child is illegitimate, it has to be taken care by the mother. But According to section 125 subsection 1 of CRPC, it says that whether the child is legitimate or illegitimate, it has to be taken care by the father. Father has an obligation to maintain children as long as they are able to earn by their own. Section 3, subsection 1, clause B of 1986 Act contemplates on divorcee's right to claim for maintenance of children. Right of children is independent of that of divorcee mother to claim maintenance. In the case of Haji Farsad versus Noorjahan, a mother filed an application for herself and 3 children, and the magistrate granted Rs 300 for the children. But the husband claimed that the right of children is ancillary and children's right under section 125 of CRPC is not maintainable. But the court held that children's right is independent of that of mother's right under clause A, B, C and D of section 125 of CRPC, and it used conjunction or, which shows everyone's rights are independent. In Noor Sabah Khatun versus Muhammad Qasi, it was held that divorced women entitled to claim for their children's maintenance until they are major under section 125 CRPC, and Muslims has the obligation to go through the maintenance of ascendants. Children are under the obligation to maintain their parents, whether male or female, adult or minor, who has sufficient property are liable to maintain their parents. But the Sharia law says that no need to take care of their parents if they are capable of themselves for doing so. But Sunni law doesn't make difference whether they are capable or not. The liability for the grandchildren arises when there is no child or the child is indigent. To take care of the stepmother is only when there is no husband or the husband is incapable of doing so. Now we can go through the case of Vijay Manohar Arbat versus Kashirao Rajaram. In this case, there was a dispute existed whether the only male had to maintain the parents and not the female. But it was held that irrespective of gender, whether male or female has to take care of their parents. Now we can go through the maintenance of collaterals. Under Hanafi law, liability to maintain collaterals under prohibited degree is only if when himself is in an easy circumstance and the relation claiming has no other means of existence or surviving himself. Shia law doesn't give any obligation to maintain the collaterals, but Sunni law gives such obligation to maintain the collaterals. Now we can go through the maintenance of wife. The wife's right to be maintained arises in 2 circumstances, that is, arise out of valid marriage and arise out of prenuptial agreement between the parties or the parents of the parties. Her right of maintenance is absolute and she has the right even if she has property and the husband is poor also. Husband is bound to maintain if she attained puberty and obeys all his lawful commands. In Chand Patel versus Bismillah Begum, wife filed a petition against the husband under section 125 CRPC for the maintenance of herself and minor child. She added he already married her elder sister also. Husband denied the marriage and contended, according to Muslim law, cannot marry sisters and it's void. The court held that the marriage to be irregular and the respondent and the daughter are entitled for maintenance under section 125 of CRPC. Now we can look into certain circumstances when she is not entitled for the maintenance. And they are when she abandoned conjugal home without a valid reason, when she refuses to access to husband, when she is disobedient to his reasonable command, refuses to live with husband, when she is imprisoned, eloped with somebody, when she is minor and marriage cannot be consummated and she deserts the husband. Now we can go through the maintenance duration. the husband has to maintain the wife until the death of the husband. When the widow not entitled to maintain during the iddat of death, divorced wife is entitled for maintenance from husband during the iddat also. If divorce not communicated to her, entitled for maintenance even after the period of iddat. If divorce is for apostasy or any criminal act, no need of maintenance during the iddat period. Under section 125 CRPC, wife includes divorced wife and not remarried and not in adultery. Until Muslim law need to maintain divorced wife only until iddat. Under section 127, subsection 3, she has to maintain until she remarried, she received whole sum under any law, she voluntarily surrendered her right of maintenance. Now we can look into the case of Shah Banu Begum versus Muhammad Ahmad Khan. Shah Banu married to Ahmad and had 3 sons and 2 daughters. After 14 years, he married another woman. She was 62 and thrown out of the matrimonial home. He divorced her by triple talaq and refused to maintain her, which was ordered under section 125 CRPC. Court held that section 125 CRPC is secular in nature and applicable for all women who refuse to be maintained. So, she had to be maintained until she remarries, even after the iddat period. Now we can go through the case of Sohra Khatun versus Muhammad Ibrahim. In this case, Supreme Court held that wife under section 125 subsection 1 of CRPC includes divorced wife also, so has a right to be maintained. Wife can sue for maintenance under Muslim law of under section 125 and also 126 of CRPC. These are the situations where a Muslim person has to maintain his wife, collateral, ascendants and descendants. Hope you all understand the topic. Thank you.